See, now that's your bond. That's in his name, right, Heather?
Let me double check that, Judge.
Your Honor, he could pay the 230 by tomorrow.
Okay.
Yes, it is,
Look-
Judge.
Okay, so you can pay that by the 9th tomorrow, okay?
Yeah,
So,
he can do that online, correct?
yes, and he's going to meet with probation just to set up a court work program. Best of luck. Keep
Thanks,
doing
Judge.
what you're doing. Thank you,
I
Mr.
appreciate
Bogart.
it.
Thank you very much.
Thanks. You have a good day, and to you and your staff. And
You
Happy
too.
New Year, Judge.
Same to you. Drew Richard Dupre, 25F 245-129A, B and C. Your name? Good morning to you. Your name? You're charged with resist, hinder, and obstruct an officer, speeding, and defective equipment. You have the right. You're not charged. Yes. I see. Defective equipment. Yes. 3 charges, 2 civil infractions. You have the right to an attorney. If you want one, I will give you one. You want a lawyer?
Yes, sir.
Why am I on there twice? Okay, you go out in the hallway. We're going to set you up with a lawyer. Either way, you're coming back in front of me, okay?
Thank you, Your
Good luck to you. All right. Dylan Marzicki, Dylan Jeffrey Marzicki, 25R511, I'm sorry, 514428. Good morning, Mr. Fakaj. How are you?
Good, Judge. How are you? Happy New Year. Good to see you.
Same to you. Your appearance?
Yes, Roman Fitzai on behalf of Dylan Marlicki.
All right, so you're authorized to enter this plea. It's going to be a plea to impeding traffic, the speeding to be dismissed, true?
That's correct.
To that charge of impeding traffic, do you plead responsible on his behalf or not responsible?
Responsible.
All right.
This hearing opens as a routine preliminary examination, but the charge immediately sets the tone. Home invasion in the first degree is not minor. The court quickly narrows its focus, deciding only that count will move forward today. Formalities follow: names, seating, and sequestration, reminding everyone that procedure matters as much as testimony. The judge's control is calm and deliberate. This is not a dramatic outburst courtroom. It is structured, methodical, and intentional. From the very beginning, the court signals that every detail will be weighed carefully.
Yeah, he needs to slow down a little though, right? 175, I'll accept the plea. I'll give him a week, okay? So he has until the, let's see, the 15th, is it? Yep. Pay by January 15th.
All right, he will do so.
And he can go right on, 33court.com, and there's no fee if he's paying that all at the same time, okay?
Very good. All right, Judge.
Happy New
Thank
Year
you.
to you, counsel. Good
Take
luck.
care. Good
Thanks.
seeing you.
Tukari Sierra Moore, 25R 514404. And can I have Graham up here? Kira Graham, seated at the table, my right, your left. Ms. Moore, come on up to the podium and tell me your name, please.
Can I see the Lord?
Okay, you're charged with reckless driving. You have the right to an attorney. If you want one, I will give you one. Do you want a lawyer? I'll arraign you and I'll explain the possible penalties and then I'll send you to the prosecutor if that's what you want, okay? On November 27 of 25, it is alleged that you did operate a motor vehicle on Huron River Drive near Hazel in Rockwood recklessly. That is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs of all of those 6 points in your license would be suspended. There'd be a hard suspension by the Secretary of State. For some reason, I can't remember if it's 90 or 120 days. Assume the worst.
When the first witness takes the stand, the questioning moves directly to identification and timing. The witness confirms knowing the defendant, confirms a prior relationship, and confirms they were no longer together. These distinctions matter. The court is not interested in emotions or history, only legal status on that specific date. Where someone lived, whether they were invited, and whether consent existed becomes central. The testimony establishes location, lack of invitation, and an unexpected encounter. Each answer tightens the factual frame the judge must later evaluate under the law.
Do you understand that? All right. Did you sign the advice of rights? Did you read and understand the rights? If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Judge.
Okay. Do you still wish to waive your right to a lawyer?
No.
I'll enter a not guilty plea, $500 personal bond, Do you work, ma'am?
I currently start working next week on Friday
Where?
at the Open Station.
All right, I'll go ahead and appoint you a lawyer for this, John. She's gonna need a lawyer too. And you go out in the hallway, tell the lawyer defendant was arraigned and defense attorney to pre-trial, okay?
Okay.
Good luck, ma'am. Either way, you're coming back in front of me. Kira Ann Graham. 25F245277. 25T644716. B 24T644312. 24F242667. Your name?
You're correct.
Boy, ma'am, you gotta show up in court. You know that?
I know.
Cannot do this. You've missed and missed and missed. All right, you posted a bond of 282 on 716B and 213 on 644312.
The testimony describing the door opening marks a critical moment. According to the witness, contact was immediate and physical. There is no allegation of conversation, no warning, no permission. The witness describes being struck, pushed backward, and forced into the kitchen. The court repeatedly clarifies positioning, sequence, and movement. These details matter because home invasion depends on unlawful entry and force. The witness's uncertainty about words spoken contrasts with clarity about actions taken. What matters legally is not what was said, but what physically occurred inside the home.
Would that cover both of those, Heather?
And which ones were those on, Judge? I'm sorry.
That's okay. So we have 252 on file 25T644716B. Would that cover that case?
362 is the balance on that.
Okay. You in 213, will that cover the balance on the set 24T644312?
That is 248 balance on that one.
Will 309 cover the balance on 25T644716A? No, that's
344 is that balance.
Here's what I'm gonna do. I'll give you a lawyer if you want. You posted the bond. I'll waive the balances on those four cases, okay? You got a 405 owed that you posted a bond on 24F242667. So I can get rid of those four cases if you want it. I'll send you to the Flat Rock.
After the initial confrontation, the witness describes the defendant leaving, followed by property damage. The broken window is acknowledged, but the court limits its relevance carefully. Objections are raised and sustained where appropriate. This shows restraint, not bias. The judge allows testimony only within the boundaries of the charge under review. Police involvement follows, adding a layer of official response. Ownership of the home, lease status, and removal from occupancy are explored. Each answer addresses a single question. Did the defendant have lawful authority to be inside that residence at that time?
Prosecutor, or I'll give you a lawyer on the other drive while suspend. It's up to you.
I'm not sure which to do.
It's up to you. If you want a lawyer, I'll be glad to give you one. If you don't, I'm going to go ahead and arraign you. That is, explain the charge, the possible penalties, and your rights on the new suspend.
Okay.
And then I'd send you to the prosecutor to talk.
I'll just go speak. Yeah,
So on December 7 of 25, it is alleged that you did operate a motor vehicle in the city of Flat Rock, County of Wayne, with a suspended license on Telegraph near Leonard at 2:33 in the morning. That is a misdemeanor punishable by up to 500 fines, 90 days jail, 93 days jail. Costs are all those. Do you understand that? And did you sign, read, and understand, John? I need those. I'm sorry. No, I got it. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Okay.
You still wish to waive your right to a lawyer? Not guilty, please enter. $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Now, I can get rid of these other ones right now for you. Mr. Kaylee, can you remember, are you out there?
Cross-examination shifts the focus to shared history. A long-term relationship, a shared child, and years of cohabitation are established. Defense questions challenge whether residence truly ended. The witness admits no formal eviction was filed. This moment introduces legal tension. The court must decide whether verbal notice and removal of belongings can terminate residency. The exchange highlights confusion common in domestic disputes, where personal separation does not always align with legal process. The judge listens closely, allowing the record to develop without interruption or commentary.
He's in a breakout room, Judge. You want me to bring him out?
No, just. Yeah, would you please, and put him in front of me real quick? I just want to
Yeah.
explain. Ms. Graham, I hope you're gonna learn a lesson today.
Absolutely.
Well, what are you doing? I mean, come on, hold it,
Too old for this.
hold it.
I'll be 40 this year.
Why would you do this to yourself? I don't understand. You're gonna still have to pay any clearance fees involved. I want to be clear.
I was gonna ask, how do I take care of getting it cleared through the?
You're gonna have to pay a $45 clearance fee, I believe, just on, correct me, one case, because I'm gonna waive any balances on the rest of these.
Thank you so much.
Heather, okay?
He should be coming in here in a minute, Judge. There he is.
Mr. Cayley, good morning. Your name? Happy New Year to you. Listen, I've got 5 cases here. She posted bonds on.
The judge's comments before the next witness are revealing. He openly questions whether a home invasion charge can survive when 2 people lived together for 12 years. He explains eviction requirements plainly, signaling skepticism. This is not a ruling yet, but a warning. The prosecution proceeds by calling the responding officer. The tone remains professional and restrained. The court is not dismissive, but it is clearly testing the strength of the case. At this stage, the burden remains on the prosecution to justify moving forward.
On 4 of them. I'm gonna waive the extra warrant fee. She's gonna have to pay 1 clearance fee, but she has 1 new suspend charge. She's waived her right to a lawyer. I'm sending you this one. I'm gonna keep the other 4. She's gonna end up having to pay those. She's been absconding for a while here. These were from August of 24.
So the other 4 have been adjudicated?
Correct. She's posted bonds,
Okay.
and she might be $35 short on this one and that one, but I'm gonna waive those. So I'm just gonna give you the 1 Flat Rock case, but I wanted you to be aware if you wanna cut her a bigger break. John, can you hand it to him? That I'm gonna keep these other 4, and she's paid about somewhere in the neighborhood of $213, $482, so that's $495, $795, $804, $1204, $1209 she's paid on these other 4.
That's clear for driver's license?
Yes. Well, I don't know. I didn't look close enough.
Okay.
She's gonna have to pay 1 clearance fee. I'm gonna make her pay on the 1 no proof insurance. I'll just have them give you all of those. Just send them all back. Okay? I just wanted you to be aware of what was going on. You go with him. I mean, I don't know if he can get you in now, but
Okay.